Welcome to Non-Obvious with Hugh Hansen.
Yes, I second that welcome. And welcome to you, He Jing. It's great to have you on here. Okay, starting out, where were you born?
I'm born in Yangtze River site in China. It's a city, one of the early city opened to the West in 1840s, right after the Opium War.
Now, how did you end up in the United States? Where did you go to? You went to school in Chinese schools, correct? Like elementary and high school and all that stuff.
Yes, I went to all the schools in China, and I went to university in Beijing. And one thing I found out actually quite interesting. Almost all the schools I went to, the properties are actually all somehow related to Catholic Church or Christian Church. Part of because probably the city actually was open to the West a long time ago. The high school I was in actually has a 150 years old history.
Jing, I think God is directing your life. I think that's what that means.
That's probably that's why I end up in Notre Dame in the United States. I have the honor, and the fortune to.
How did you end up in? What age did you move to the United States? Probably with your parents, maybe, or what?
No, yeah. When I was in the States in 1997, I was 23 years old. So pretty old guy when I was first time in the U.S.
Why did you go to the United States?
It's at that time it's pretty straightforward decision, right? U.S. really meant something very, very different, right? Very something full of hope, promises. So lots of young people, in my generation, even for now, right, want to come to the U.S. For some new opportunities, for study, for higher degrees, or for career opportunities.
Hold on, we're getting a lot of background noise. Is that from your area? All right. Okay, it's gone now. So what did your parents think of you going to the United States?
I think they're very proud of me. It wasn't really something common. So I think that's made them proud.
Okay. And where did you go when you at first in the United States?
The first city I landed is Los Angeles. Then I quickly transferred to Chicago and then South Bend, Indiana.
All right. So this was to go to Notre Dame Law School.
Yes.
Okay. And
3 years there, and then got my JD, and then moved to California. Right. Became a patent attorney.
How did you pick Notre Dame?
I guess there's someone calling. But to be honest, at that time I was, choosing the different schools, and then Notre Dame is one of the really, really good ones. So I picked it, probably out of admiration, out of curiosity, and I was really grateful for the acceptance by the school.
And what type of courses did you take? What were you focused on, or were you just taking everything, or what?
It was a really regular JD curriculum. And one thing actually I found out I love most include the moot court and the trial advocacy. Even though I never end up being a trial attorney in the United States, but I found that the trial advocacy and the moot court are really the most fascinating courses for me. The very American, really reflect something quintessential to the American litigation system.
So undergraduate in China, you were, or what was your degree? Were you in science? Were you what did you focus on in college?
My major was physics, actually. I was studying physics. A lot of my classmates. They all came to the United States for higher degrees in the physics or electrical engineering or software. And many of them end up being as a great engineers. Some of them are physicists.
Mm-hmm. Okay, and all right. So now you're in law school. You graduate, and why did you go out to the coast?
It's probably because of the copyright law. I graduated in the year I was interviewing in 1999. At the time, the Napster case was a very famous case, and that's probably the very first time the technology clashed with the copyrights. That's one of the most probably landmark case when we were in the law school. So I was very intrigued by what's going on in Silicon Valley. And I was fortunate to get a job from Fenwick in the West. Fenwick was defending Napster at that time, so that's why I picked that job and went to Palo Alto.
How long were you there?
I was there for about 2 years. Then I realized, wow, writing patents it's a very sophisticated job. Really requires a lot of the different set of skills. I got some very solid skills, but I feel like it's a job too quiet. I want something probably more full of more challenges. And plus, there are so many lawyers in the U.S. For a Chinese guy like me, I thought, well, I better just find something more interesting, more challenging, using whatever I learned from Notre Dame or Silicon Valley, and doing something interesting. So I came back to Asia. I got my first job in Asia with Baker McKenzie, and that's how I started my China IP career.
I know I put it on mute. So, all right. Okay. And where did you go? Where did you go in China?
I actually I spent about 7-8 years in Hong Kong, part of China.
That's not
That's
China.
where the head.
Come on.
Well,
you might as well have been.
speaking.
You might as well have been in New York, frankly.
Yeah. So I stayed in Hong Kong for about 7-8 years. That's actually the headquarters of Baker McKenzie's like the China IP practice. It's also very close to Shenzhen, right? Which the city you visited before a couple of times, and very close to Hong Kong. And then my first case in Baker McKenzie is actually cross the border. Went to Shenzhen, dealing with something about a trademark counterfeiting case in Shenzhen. So that's my first exposure, to the real practice in China.
Well, in Hong Kong, did you get the feeling you were in England or anything else? Was it still very influenced by colonial days or what?
I don't know what's the colonial influence, but it definitely very worldly place. And it actually has a lot of very traditional Chinese components, which we don't even see that often in the mainland China. Obviously, it's very Western and a lot of British components. And we actually spoke English most of the time as our working language. It's probably much less so these days. But even in 2002, between 2002 2008, we still use English a lot in office.
Well, when was the first time you learned English?
I was lucky. I don't know whether because of the city I was born to was sort of open to the West earlier. I learned English, all this alphabets when I was in the, I don't know, year 9 actually. It's pretty early. It's not very typical in China though. It's just a public school. Somehow the school offered the English curriculum at the year 9. It was very unusual. In the 1980 83 or 84.
Okay, so part of your, right now, I'm just curious, in a week, what percentage are you speaking English in that week?
Back then, or you mean now?
Now, professionally.
Professionally, right now mostly still in Chinese. Probably only when we are jumping on the call, with you, with other friends or colleagues or clients in the U.S., then we speak English. It's
Okay.
maybe 10%.
Okay. And all right, so now you're back in at China. You go to Hong Kong, and then Shenzhen. Where did you go from Hong Kong?
I went from Hong Kong to Shenzhen for lots of work, for lots of this China IP cases. That sometimes actually when I blind my probably had produced this bias or prejudice, right, against Shenzhen between 2002 to 2008, because all I was doing in Shenzhen is all somehow dealing with infringement or counterfeits. So I probably really underestimated the huge potential of that city. Now, almost 20 years later, Hugh, when I brought you there, I think 2 years ago, right? Well, none of us actually, I did not really expect the way Shenzhen turned up when I was starting my China IP practice in 2002, 2003. So that's a kind of a cost of IP practice.
So explain to our listeners what it's like now, Shenzhen.
Wow. It's, I don't know what's the best comparison. It's now almost 20 million people, has all this, probably the most leading tech companies in China or even the world. You all know the big names like Huawei or Tencent or DJI, if you play those Jones in the US. It all came out of here, and then it's said to be the center of manufacturing for the whole world. But now it's way bigger than just manufacturing. Lots of R&D, lots of designs, and the whole city is really booming. So that's just
all right. So where did you go from there? Beijing?
Yes. Then I moved from Hong Kong to Beijing in 2010, and soon after I moved to Beijing with my family, I decided that, well, it's probably the time I should try out to build my own practice. So I left this very, very good law firm, Baker McKenzie. I'm very thankful for all the training I got from there. We got a lot of friends. But now since I moved back to Beijing, I just starting developing my own practice. I joined a smaller firm, a boutique firm, which is a really good one, CY Partners. Started building the practice. Actually, the first marketing trip I had after building my own practice is coming to your conference, Fordham International IP Conference. So, I think 2011.
So I think what you're saying is my conference was the key to your success.
That's all the beginning. It's really representative. I still remember how overwhelming the first conference was to me. It's like, what's this? What was this? Professor Hugh Hansen talking about? How could he say those things to those great judges?
The judges say the same thing now. Okay, so when you say you started your own firm, how big was it? 1 or 2, 3 lawyers, or what?
Well, I did not really start my own firm back then, 2011. I really joined a very already established boutique firm. Then I had to spend 2 years there, and then I realized I probably like the full service firm better. And at that time, a new firm Anjie, ANJIE, the law firm was being built up by a bunch of others almost at the very beginning. So I decided to move in, join them, and because they have also corporate lawyers, antitrust lawyers, commercial litigation lawyers, we thought, well, this is good. Let's build something new. So I joined there in 2013. That's how that's sort of like a new stage for me to build a practice. I was there just with one associate, partner with others, starting the IP practice.
And you built that up pretty quickly.
Well, it took. It's not easy, right? Building a practice always takes time, and I was there for about 7 years. Developed a team around like 40, 50 people. 2000 until 2020, and so in the middle of COVID-19, my partners, I mean the people in my team, my partners and myself, we actually made a decision which is quite bold. We hope it's the right decision. We decided to start a firm of our own. So that's how we started as a new firm called the GEN law firm. The Chinese 己任 really means our own responsibility. So that's how we started. Now we have already we have some other partners join. We have almost 70 people in 3 cities: Beijing, Shanghai, Shenzhen. We just had our Shenzhen office and Shanghai office opened up. We have all this IP practice, antitrust, data privacy, environmental law, commercial litigation, and now we have a 2 corporate partners join us in Shanghai office. So this is truly a new law firm we started.
That's very exciting. So your practice, how would you characterize, if someone asks, your practice of your firm? How wide is it? What are you focusing on?
For me, my sometimes I feel a little bit odd to say to people, said, "Wow, I'm a really like a China IP specialist." When I say specialist, I know most of the areas in IP, patents, trademark, and even copyrights and unfair competition. It's a little bit odd to say that. If I'm a U.S. lawyer, if I say that, people say I'm pretty a fake one. But in China, we probably because the IP practice relatively young, right? Our whole IP system just started from 1985. I was like the first generation IP lawyer in China. I was lucky to start as a patent attorney, and then I did a lot of trademark work in Baker McKenzie. And then I was fortunate to serve companies like NBA and others in copyright work. So in a way, I am have a diverse practice. But seriously, these days because we have a really great group of partners, I focus more on patent related work, anything related to patent litigation and licensing, and even the standard essential patents or the friend work. Another area I love most is actually IP policy related advocacy activities. That probably explains, why, Hugh, why I love your conference, why I always come to Forum IP conference. So now makes sense.
Yeah, it does make sense. All right, so how much time do you spend running the firm or administration as opposed to actually practicing? Because you're a big honcho in the firm, right?
Right now, one of my passion is to really coaching partners and nurturing people. Lawyers are not really manageable. This is I'm saying this out of respect of lawyers. It's to me, it's really more about coaching them, providing the guidance, or more providing suggestions. It's not about really teaching people or ask them to follow certain orders. It's more about finding ways to empower them, building the relationship with the partners. One person, no matter how great one person is, right? The group partners putting all the wisdom, working hard together. That's the true core of competitiveness. So my time really spending on the management is really more about coaching people. Like even yesterday, I just, if I count, I know I spent like 3 hours coaching my partners on their practice or how they deal with the cooperation with other partners, how they develop market. Like even this morning, I spent 1 hour writing a very important advice, and then spent another hour having a conversation with another partner on the building relationship with other partners. So that's a little bit of flavor of what my life is. But I really love it. Love to spend the time on coaching, leading people.
All right. So your client base, is it Chinese people? Is it US, Europe? Is it a mix? I mean, who are your clients?
It's in the very beginning, probably all thanks to all my trips to Fordham. most of my clients are international clients, American clients or European clients, some Japanese clients. I have some really good Japanese clients. I was really grateful to help them with some difficult matters in China. But over the years, one thing very interesting is that more of Chinese IP clients come to us for quality service. This probably explains that all this improvement, all the progress, right, the China IP system has been making over the years. I think our governments, our systems see that, wow, there's an inherent need of enhancing the IP protection, even just for the sake of protecting the interests of domestic IP owners. So our practice also reflect that. We're working on cases for some of the largest Chinese companies, some of the emerging, the popular brands. It's just really interesting to see how our practice been evolving. I didn't really expect it. I was hoping this could happen, but it's definitely come much faster than we thought.
So most of the time, your clients own IP as opposed to they're worried about using someone else and infringing IP.
Yeah, most of the time, we, our clients more on the owner side, brand owners or the patent owners or copyright owners.
Okay. All right. So what are some noteworthy IP trends in China?
It's we are actually in a very different time. To be honest, I'm not even trying to search what are the direction. I've been doing this China IP work since 2002. I wrote my first paper back in 1995 when I was at school in the Chinese law school. So I have almost 30 years of exposure. Now this is a completely new time now in terms of the China IP. This is really correlated how China been growing the powers, and China and the U.S. Sort of now being talked about in like in an equal or on the same table. We at least we did not really anticipate this when we started our legal career. So I think correlate to that. I think in China IP, the trend is that there's something big is going on. It's not either good or bad. I think some kind of big test is happening. A big thing that we are seeing this is all this friend cases that are happening in China. It's certainly controversial. To some extent, it's actually making people worried. It looks like the Chinese court issued an anti-suit injunction in friend cases, not just in favor of Chinese companies, right? Also in favor of like even non-Chinese companies. And then it's causes like an anti-suit injunction, not even anti-suit injunctions in the friend cases. So the Chinese court is definitely sort of in the center of something quite big. Mm-hmm. I sometimes depict this that Chinese IP system been growing so quickly. Now it's probably the time to go through some big tests. Big testing, when I say big test, it's really about in a way that whether our courts can really deliver the results that have this world of global credibility and can really convince people, convince the big companies, the big firms, the big owners or big inventors are willing to trust their big case in the hands of the Chinese courts. So this is probably the one of the most significant things that we are witnessing right now. The second trend is more about like something related like WTO reforms, something more about the multilateral agreements. I remember even when I was in your conference the first time, the session I always skip is the multilateral, the agreements part of the treaty. I feel like, wow, it's really not that relevant to us. But now, to be honest, China is actively thinking about joining the CPTPP, right? The Comprehensive Progressive Trans-Pacific Partnership. This new generation of trade agreements. It's all the IP things is at the center of it. And everybody knows that IP was a huge part of U.S.-China Phase 1 trade agreements, and all this the global impact or even geopolitical aspect, the thinking are all brought into the IP matters. That's why it makes things quite complicated now. I'm actually even now stretching myself to learn a lot more about the international relations. So don't be surprised next time I talk to you more like from more from a geopolitical aspect. I think that just because the IP is no longer the kind of IP we've been talking about in the past decades.
So there are aspects like the international. So what is the Chinese government thinking about dealing with the US or someone else? What are the IP infrastructure doing now? Are the courts doing? What about the Communist Party? So does someone have to think about all of these things about what the future is going to hold? Or is there some way to predict the future? Or is it just, we don't know until it happens?
Of course, it's the future is always uncertain. One thing I don't know if Hugh, you're happy to hear about it. At least in China, I think we will say at least the government declares very pro IP. In the latest remarks by our President Xi, he said protecting IP equals protecting innovation. It's a really just equivalence making there. It's been made there. So the government's having this is
yeah, so I saw that, but then I'm wondering if he's talking about protecting it for Chinese or protecting it for everybody.
That's a part that comes down to another aspect, and also national security and the international competition are also linked to IP. And the government actually always has some concern about this IP misuse. It's I think in our dialogue, in our domain of language, I think the judges or policymakers don't want like a quote unquote non-Chinese IP owners or Chinese IP owners misuse, abuse the IPs. So that kind of dialogue has been there for quite a long time. But now, given what's been happening the last 4 or 5 years, it's been during Trump administration, all the trade sanctions or the cutting off the supplies of the chipsets to companies like Huawei, making all this thinking quite complicated now. So people are even talking about, hey, we need to make sure the security on the IP. We don't want to be like being cutting off on the like the supply chain, even in the IP area. I personally don't really quite understand how that can be linked together. But when people equals IP to innovation or technology innovation, when they saw that the technology innovation at the core of the competition between China and the US, the IP somehow be really geopoliticized. Now, when people reading about today's news, we have people saw that wow, the Biden administration or European Commission talks about China more like a strategic competitor. There's like a rivalry. There's a serious competition between these two countries. So somehow IP is all been put on a very different light. So that's why, Hugh, I really think this is getting very, that's why I said we are in a very different era now.
So how does that affect you as a practitioner? Is this above here and, sometimes you have to think about it, or is it settling down so that these concerns for your international clients are more important each day?
Well, when I do my advice to my clients, I do put it to different distinctions. A part of the advice is more about the logic of the law, logic of the IP, and the logic of the Chinese procedures. What does it mean? What's the implication? Whether whether this is flawed or not. Another part is that I keep going to is the policy context. I trying to explain to my clients in policy context. Before I talk more about the the policy context. Now I find myself often to have to dig something in a more geopolitical aspect, international relations, how China looking at the world, how China looking at maybe the next stage of the free trade agreements, how China looking at the U.S.-China phase one agreement. We have to put a lot of things in a policy context. It's actually challenging, also very interesting. It's actually make our job more interesting. Although the answer it's much more complicated.
Yeah, well, normally my experience has been, if you tell a client that it's a very interesting issue, it scares the life out of them, because that just means more litigation,
I
more
know.
things, and they can't predict, and they're going to be paying the lawyer more than maybe they thought they were going to do. But so, okay, Chinese Supreme Court issued a ruling on jurisdiction. And there seems to be a Beijing court view and a Shanghai court view. What is that all about? Or am I wrong on that?
You're not that far away from the from the reality. One thing very interesting is that China set up this is the Supreme Court's IP court on a model of your federal circuit. Right, the idea is to make more uniform, more consistent standard in the IP, in the patent cases and the trade secret cases. That's a very admirable goal that has been started for a couple of years. Even before that, China set up dozens of the specialized IP courts on the intermediary court level, bit like your federal district court. And then on top of that, now we have the Supreme Court IP courts as our federal circuit. So our federal circuit has issued, quite a number of these model cases as a guidance. We do not have this precedent stale decisis system in China, but we are learning more from the common law system and issue more guidance, the guiding cases to reflect the ongoing changes. So sometimes we did see that there's a different approaches among the Beijing specialized IP court and Shanghai specialized IP courts. Sometimes some Shanghai courts are more innovative. Sometimes the Beijing courts are more open-minded on certain issues. Now, the Supreme Court IP Court arguably has gathered some of the most senior, most experienced even U.S. educated judges there. They are becoming more and more active. They're also working very hard. I'm very often very sympathetic.
Okay, which court is this? This is the Shanghai court, did you say?
No, Supreme Court in Beijing, the IP court, our federal circuit, circuit.
Okay,
yeah,
gotcha. And so you're saying then it's a leader, it's an intellectual leader as well.
The leader is
in terms of, all right, what do other courts look to? Does the Shanghai court look to what's going on in Beijing and vice versa, or are they all in their basically their own worlds? And so if I'm a practitioner, I really have to know what they're doing there as opposed to something broader, or what? How is it working?
at both actually. We do look at like for example, we do looking at the leading cases done by the Shanghai IP court, and also we need to be aware that what the Supreme Court IP court would do, our federal circuit, to make it easier, our CFC is going to do. One thing we are seeing is that our judges, because Chinese judges are relatively young, to be honest, when we say most senior, most experienced, and they're probably just having maybe 5 more years than their colleagues in Shanghai court. And our judges, IP judges, are relatively much more educated. Um, so they are quite confident. They're learning a lot from maybe the US cases, European cases, to do the comparison. They have regular seminars among themselves. So sometimes we saw there's some kind of a competition as well. So we better learn all the cases in the different area when we go to that court.
Oh, that's interesting. So do you have a lot of let's say you have a foreign client and it has a Chinese-wide issue. How much discretion do you have as to where you can bring the case?
We are relatively flexible because China has this. China's not a federal system. It's for all the courts, it's like a single system, single courts. So whenever, for example, in the patent cases, whenever we can find an infringement item in that city, we can basically file that case in that city just by suing both the distributor, reseller, and the manufacturer. So we have relatively more flexibility. But in reality, we still think that the courts in Beijing, Shanghai, Guangzhou, or Shenzhen are more mature. So for the enforcement cases, the plaintiff type of cases, we still go to more of the major courts. But I know sometimes we also advise some of our more risk-taking clients to try some of the newer IP courts in other cities. When those cities are also quite a major one, they probably also have 10 million people as well, but they may not have more experience in patents or trade secret cases than those in Beijing or Shanghai.
Okay, well, just between, let's say, Beijing and Shanghai, is there ever a situation where you say, well, this really should be in Shanghai, or this really should be in Beijing, but there is not enough of a difference that would drive you to one or the other, or because of, as what you said about the Beijing court, more educated, maybe more thoughtful or modern?
Well, right now we all have a view. Also part of the reality, like the Beijing courts are the Beijing IP courts really loaded with a ton of cases, so they're getting a bit slower. Really not their fault. When we say slow, we're talking about 2 or 3 years compared to like 1 year we've been used to before. So sometimes we are probably willing to try Shanghai or Shenzhen. They are getting faster. We're talking about plenty of cases. And also some of the local courts, like the Pudong district in Shanghai, they are very progressive. They don't deal with the patent cases, but they are really open. They are really progressive in like a copyright cases or unfair competition cases. They are, China is not the case law system, right? It's, lots of things depend on how you interpret the statutes, like unfair competition law. So we definitely saw that, the Shanghai, the Pudong district, where it's like a real Manhattan in the New York. The Pudong district is like your New York, southern district. So they're very open-minded. And then, so for some of the cutting-edge copyright cases or unfair competition cases, I probably would suggest my client to try with like Pudong District Court.
Thinking about Southern District and all that, are there any? Would you say there stark differences at all between bringing the same case in the U.S. and China?
As a plaintiff,
Yeah.
I know there's a view that in recent years, or even for decades, the protection of like the software patent cases are being weakened, right?
I think for some
Yes.
reason your picture, I'm seeing a picture rather than you.
Right. I just turn on my video. I just turn on my video. Yeah, I know, because I'm watching the power.
Okay.
Yeah. So I think in terms of fighting cases between U.S. and China, I know there are some dialogues, based on what I learned from Foreign IP conference, right? They always talk about the weakened patent enforcement in the U.S. In China, it's a faster, but somehow we know that it's still not very certain. And that's why I said that China needs to really go through some big tests, especially on the patent litigation. When we talk about the cases between big rivals, when we talk about maybe the major, my patent owners suing maybe major, Chinese defendants, whether those outcomes will be really credible or be trusted by the global community. I think that's something still need to be tested. So we know some of the patent owners have done some tests. We also help on some of the cases. The results are mixed. The results are really mixed. So that's why some of my colleagues at the firms, I know they say, wow, China really, really fast. But on the China patent litigation, they said very, very fast, very quick. But we know that in our experience, it's not that consistent. Especially if for a U.S. company or foreign company, it brings broader cases based on some complicated patents. It's the results may not be, the speed may not be as fast as you wish. And in the recent years, the pharmaceutical patent owners are also find it quite troublesome in some of the validity cases. So now, but the only the thing is that the stake in China become much harder. The stake in China markets become much bigger. That's why whether this is better than the US or Germany, I mean, in terms of our system or consistency, still companies are getting more and more serious about litigating in Chinese courts. At least they whether they want to enforce their patents or IP here, or they want to watch whether they might be brought into the lawsuit here. One interesting thing in China is that we saw lots of patent cases, lawsuits are happening between the firms that may be going to IPO, going to be listed in capital markets. This this happens more and more often now when a company prepared to be listed to do the IPO. There's always some kind of patent litigation filed by their competitors or the dominant player in that industry. That's probably one of the evidence to show that Chinese patent litigation system becoming more and more useful or given more weight by Chinese companies.
Okay. Let's move over to antitrust a little bit, anti-monopolies and things. What's going on? Do you see changes? I see sometimes people talking about changes. What is the situation now in China in IP and antitrust?
That's goes to what we spoke about at the very beginning, all this anti-suit injunction. Antitrust law are being given to a renewed focus these days. 5 or 6 years ago, antitrust law played a big role when the government was investigating Qualcomm and other patent owners. This big fine was imposed on Qualcomm. That case even preceded, right, whatever happened to Qualcomm in the US. in the last couple of years, it's sort of getting quiet. At least we did not see any big announcement about the investigation or the outcome on the patent owners based on antitrust law. But just in the last 12 months or so, in all those friend cases, the implementer are getting more aggressive. They are using the private lawsuits, making claims on antitrust violation, saying that patent owners were charging excessive pricing, ask the courts to make a determination about friend base. So somehow the antitrust and IP related disputes become a hotspot. Another related phenomenon is that China somehow now using the antitrust law to really investigating the tech companies, the big online platforms, whether it's Ant Financial or the other tech companies. This is sort of a little correlated to what's going on in the US as well. So that's why the antitrust law becoming quite a popular topic these days.
Now, in terms of expertise, would you say the Chinese courts, if you brought an antitrust suit, that they would be trying to figure it all out before they do anything, or there's enough of those around that there's a body of law that the courts, at least some of the sophisticated courts, can deal with it very easily?
So what's been driving the antitrust investigation is the enforcement authority, the regulators on we call on the government side, be like your DOJ or FTC. The courts have been handing down various antitrust decisions, but mostly on the more traditional antitrust cases. Not like a resale price maintenance, the RPM. Lots of cases in that area. So far we have not seen any significant cases done by the court in the IP area. There was one like a case about refusal to deal claim against the Japanese companies on the IP licensing, but I thought that case still pending for without trial for at least 4 or 5 years. So that's why this is probably part of the big test I'm talking about.
Mm-hmm. Yeah, I mean it's interesting. The antitrust regulators, like in our country, the FTC and the antitrust division. The FTC was created because of nothing else was going on, and so people were concerned that there was going to be no really check on monopolists, what they think, and everything else. And so there was a heyday of that. But now the FTC, our FTC has a mechanism where they can try the case between their own judges and everything else. Well, actually, you've noticed recently they're not even doing that. One is because it takes a lot of time, but two, that leads them to a certain court of appeals who might not, enamored of what the FTC is doing. So they're just actually going into court like any other litigant and finding that that's a better way for them to go. And our antitrust division, goes through spurts, but depends on which president is in now more than it did in the past. So it'll be actually interesting to see what the Biden administration does in that area. But so I guess the same thing is true in China, is that you can have the regulators, but they can be active or inactive, and then that means what the courts are going to be doing, active or inactive. And it's an interesting, not easy puzzle to figure out sometimes.
Right. One of the observation is that our regulator do not want their decision to be reviewed by the courts. But well, they probably hate to be reviewed, right, by another branch of the government. One thing very interesting is that our regulator recently imposed a big fine against a pharmaceutical company They were making this active pharmaceutical ingredient, API ingredients. Apparently, the charges that are manipulating the price by take advantage of market position. It's a huge fine, hefty fine was imposed. A little bit to our surprise, also excitement. The company actually fought back and then filed this administrative appeal to the court. We don't see the result yet, but this is quite a serious a challenge against the regulator decision.
Yeah, very, very interesting. Oh, by the way, how you started your own podcast, right?
Oh yes, I actually out of inspiration of your podcast. When I was visiting you last time, I tried it out during the COVID-19 time last year, and I tried about 6 episodes. It's called an innovation policy.
Well, good. Well,
Yeah.
I definitely want to listen to them. And you better not be stealing anything from me. I'm just telling you right now. Okay.
Well, the idea is not protectable.
Oh yeah, you smart ass IP people. I'm telling you. Okay. Let me think. Friend setting. Anything we should know about that?
We were just in the middle of it. It's a proceeding that I think all the stakeholders are trying to test out the system to see what will come out. So there are a couple of cases, big cases are going on, and we hope that our judges will learn enough from all the best practice and then give a fair result. Of course, I personally do have a reservation even on in what circumstances the Chinese court should take on these cases. Right now, what's is quite disappointing is that our courts actually allow the implementer simply to file the case under this general or vague the contract dispute, even though there's really no contract existing. They're basically, we think they are abusing their the system to force the patent owner to fight on the front rate in a court. The implementer find it desirable. This is I think this the problem. I personally trust that our judges are capable. They could be capable, but actually the way right now the jurisdiction is being handled, being exercised, I think that's there's a big problem.
Okay, and in other words, there's some unfairness and maybe discrimination against non-Chinese. Is that?
It's well, it's not just really about against the non-Chinese or Chinese, but somehow even Ericsson and Samsung cases are also somehow brought into Wuhan. Well,
okay, so all right, it's okay. So at one point you were thinking about, which I was very excited about, starting a branch of your law firm in the United States. What happened to that?
We're not giving up this idea. It's we're always hoping that we can match the demands of our clients. So this is still part of our plan, but we are just actively watching what we could do. And I think most important thing is where we can find the good partners. But in any way, we already have lots of good friends in the US. I'm not so stuck whether we have to open the office in the US. We we're open. We're just open for all the possibilities.
Okay. Did you? I didn't. With some little bit of background, I didn't get the. So if you did, you could choose the West Coast, the East Coast, New York, San Francisco, LA to do it. Is there any thought about where the best place to start out would be?
I'll pick some place close to you.
The best place, of course, would be New York. And why I say that is you're going to have a bunch of Europeans come to New York for various reasons. They can stop off and talk to your firm. No one is as, if you go, as far as Europe concerned, I don't know if they ever go to the West Coast, but if to bring in more European clients at almost no cost to them, where they could, huddle or talk or something with your law firm, no travel expense. If you're in New York, you had an office in New York, you could start, and that, of course, I think could generate other things. Anyway, it's just a thought, and I do want 30% of any revenue from New York. I mean, I'm just warning you right now.
Yeah, I would say that that will be a really a symbol of my appreciation to you and to your conference, which is started my practice.
And you're going to be there this year, right?
Well, as soon as the border is open, as soon as you announce your the Fordham International IP Conference.
Yeah, good. Just trying to think. All right,
looking forward to.
Yeah. By the way, everyone else, April 8th and 9th, be there or be square. Now, what is the best way for some Western company? There's some fear of going into the Chinese system, whether it's justified or not, maybe from past actions or whatever. What is a way that people can sort of become more comfortable maybe bringing actions there? Is it, of course, they could hire your law firm. But
well, this is a more like I don't know whether it's the right analogy. I just thought that there may be some a little bit of wisdom. It's a bit like someone, right, really really overwhelmed. They want to get fit. You sort of know what should be done, but it's very hard to start or not sure you can keep it up. I think coming to a very different system, which may not be comfortable, probably the practical way, assuming right, it's the business justify it. The practical way is getting something small done, getting some small victory. So build up the muscle gradually. Don't try to test the system right with your most significant system problems to test it out. You can easily become a martyr. Ideally, you start from something small and have a strategy and then build it up. And that's one very important part. The other way is that making friends and be part of the group, be part of the business alliances, getting all this right advice, learning from each other, borrowing people. China just, I think it is a more and more important market. We're consuming a lot more. We're learning from the US. I don't know whether it's a good thing to learn. We're consuming a lot more. We import a lot more. So I think all this the serious business want to come to this market, and then there are just a lot of opportunities, and of course stake is high. The challenges, the risks are there.
Okay, that's good advice. Okay, final question. What is if there is? Do you have any future goals as a lawyer? You've pretty much done it all. What is your next step, or is there's no need for next step? You're already there. What's going on with you in the future?
Well, Chinese lawyers are not American lawyers. We all call lawyers. Okay, the role, the expectation of lawyers are quite a different. The career paths of lawyers here are different from the career paths of lawyers in the U.S. So I want to build my law firm into a very high quality one. And we actually putting ourselves into this geopolitical consultation. We call global affairs consultation, in a way that we want to give more guidance to especially to ambitious, responsible Chinese companies to go overseas. Of course, we want to help the the multinational companies to steer away in China. So that's more a consulting part. Some of my partners are working on that. I'm also quickly picking it up to be the good strategist. We are just hoping that the kind of a combination of service can build somehow providing the next generation of the firm.
Oh, it sounds great. Well, Jing, thank you very much. This has been fantastic. Is there anything else you'd like to discuss before we close?
I just so much more looking forward to coming back to New York, visiting you, be part of the learn, debate, and have fun with you and all our friends in the conference.
Excellent, excellent, and I'm looking forward to it too. All right, well, thank you very much. This has been great, and I look forward to seeing you in the near future.
Yeah, thank you, really. Thank you for inviting me and giving me this awesome opportunity. And then please stay healthy, stay well. Yeah.
Excellent. Okay, thanks a lot. Bye-bye.